First of all, thanks very much to Jean, who didn't invite me to the 2014 conference, but did allow me to come to this one. And to CK, of course, for doing much more than simply sending us all emails. So thank you for all of you for being here, for listening to this presentation, which I have basically written about 2 days before arriving. In fact, was doing in the room last night, which is why I was late to drinks. I took a new job this year, so I had to teach 4 new courses, plus I edited a book. So things are sort of right down to the wire here. So this is going to be a little bit more, it's not going to be as chatty as the first 2 presentations were, a little bit more rehearsed, but that's, I'm going to be relying on notes really heavily. But hopefully this still is of some interest to some of you. So my talk here is on business and human rights, on the continuum of soft to hard law. And I thought I'd begin by just sort of briefly introducing you to the Rana Plaza disaster, if you hadn't heard about it. That was obviously the collapse of the garment factories in Bangladesh. So in the wake of disasters like this, as well as other ongoing human rights abuses that are being perpetuated by corporations, today the idea of the business and human rights movement, or what I'll refer to as BHR, continues to grow momentum. The idea of linking business and human rights issues is no longer viewed as 2 distinct systems which operate in isolation from one another, but is rather seen as a predicament that must be addressed. Now, nevertheless, despite the growing recognition of the importance for corporations to address human rights issues, responsibilities for corporations in this area have mainly been situated at the voluntary level. That is, corporate human rights obligations are mainly phrased in permissive rather than mandatory language, and enforcement of these voluntary obligations is either weak or more likely non-existent. So for that reason, corporate human rights obligations probably best termed as soft law. Recently, however, there have been some attempts to harden the law in this area. So several countries are currently negotiating a binding business and human rights treaty, and there's also been efforts made at the domestic level to harden business and human rights issues. And we'll look at 2 of these today. These are efforts that are currently being debated in France, as well as efforts in the UK. So against this background, my talk today focuses on locating the BHR movement. And what I will talk to you about is the continuum from soft to hard law. I will also look at efforts to see whether hardening business and human rights initiatives are warranted, and if so, how best we should encourage this hardening process. So I'll make my talk in 3 parts. First, I'll talk about what soft law is before turning to examine its advantages and disadvantages and comparing these against hard law. And finding that soft and hard law operate actually on a continuum, I'll then seek to place the BHR movement on that continuum. And finally, I'll discuss whether BHR initiatives should actually be hardened. So let's begin by taking a look at exactly what is soft law. Now, Jerome gave us quite a brief introduction, and I'm actually going to refer to the same commentators that he was talking about, but he flipped through his slides so quickly, I feel like I can still talk about it. So there's actually no universally accepted definition of soft law. It generally refers to an international instrument, other than a treaty, that contains a principle, a norm, a standard, or other statements of expected behavior that are non-binding in nature. Now, that being said, soft law is not exactly the antithesis of hard law. More likely, it represents one end of a continuum, which ranges from binding legal obligations on one end to complete freedom of action on the other. And indeed, agreements or international treaties, which are traditionally thought of as hard law, may in truth actually not be hard at all. So commentators have argued that only agreements that are precisely worded and specify the exact obligations actually qualify as hard law. So whether something is hard law or not actually appears to be dependent on the binding nature of the obligation, the degree of precision which is attached to it, and whether it involves delegation to a third party for interpretation of the instrument. Now, one of the reasons soft law has become so popular is that because it has so many different advantages. So these advantages include its flexibility, which allows for the formulation of responses to problems or changing circumstances as needed. It also provides a useful ground for areas of the law that may not be ripe for a binding instrument due to a lack of state consensus. It also lowers contracting costs, and in particular reduces the cost of exceeding sovereignty in a more legalized instrument. And finally, soft law serves as a complement to hard law. It can help codify norms in an area, which can then be transformed into hard law, or alternatively, it can supplement existing hard law. Now, there are a number of different advantages to soft law, but actually, in some cases, increased legalization, or what is known as hard law, may actually be preferable. So legalization enables states to signal the credibility of their commitments, and this is particularly necessary when there are coordination or cooperation problems between states. It also prevents states from engaging in opportunistic behavior or from reneging on their commitments. It can further enhance the enforcement of a state's commitments, especially if interpretation of the law is delegated to a third party. And finally, legalization can enhance the legitimacy of an obligation, and this in turn can act as a compliance pull. So based on these advantages of legalization, commentators have argued that we should rely on hard law when the benefits of cooperation are great, but the potential for opportunism and its costs are high. Hard law is also recommended when non-compliance is difficult to detect or to circumvent problems of incomplete contracting by delegating these issues to a third party. That being said, commentators also argue that there may be difficulties in relying on hard law because it results in significant costs. Most notably, it constrains state behavior and it impedes their sovereignty. Hard law also requires greater precision in outlining obligations, and this can lead to excessive rigidity, or more problematically, it may prevent the inclusion of consensus among parties at all. Now, conversely, these same commentators recommend that we should rely on soft law if we need to counter high contracting costs, particularly in relation to sovereignty, or when issues are new and complex. And indeed, by relaxing one of the elements of legalization, the binding nature of the obligations, the precision of the obligations, or the delegation to external authorities, soft law may actually ultimately be easier to achieve for the parties. So we've seen then that the difference between soft and hard law is not quite as dichotomous as it may appear at first glance. Instead, it appears to be fluid and operates on a continuum. Of course, the next question is where on that continuum are BHR initiatives? So to look at that, let's have a quick look at some recent BHR initiatives. Now, I'm only going to focus on the most broadest ones because of matter of time. So one of the first initiatives that you may be familiar with are the OECD guidelines for multinational enterprises. Now, these were guidelines that were put together by the OECD countries mainly as a counter to developing countries' efforts to harden multinational conduct regulation. The OECD guidelines consist of broad, non-binding standards and practices for corporations to make positive contributions to economic and social progress. Since the late 1970s, we also have labor issues being regulated under the International Labor Organization's voluntary standards for labor in the Tripartite Declaration of Principles Concerning Multinational Enterprises and Social Policy. Now, in 1988, the United Nations actually made a concerted effort to harden the law in this area by putting together a working group to look at business and human rights issues. These efforts produced what was known as the norms on the responsibilities of transnational corporations and other business enterprises with regard to human rights, also better known as the UN norms. Now, these were a draft code of conduct for regulating multinational corporation conduct. This would have been the first non-voluntary initiative to detail obligations in this area. However, due to business opposition, the norms were never adopted. Instead, the UN went on to enact the Global Compact. Now, we also saw that in one of Jeroen's slides, but again, something that he flipped through quickly here. So the Global Compact is a policy initiative that advocates good corporate practices in several areas, including human rights. Now, this is an initiative that has been widely accepted by business, but it lacks binding standards or any type of monitoring mechanism. Now, given these shortcomings, the UN actually continued to push forward with initiatives in this area. So in 2005, it appointed a special representative, John Ruggie, to examine the issue in greater detail. Now, Ruggie ultimately produced the Protect, Respect, and Remedy framework, which detailed 3 different but differentiated responsibilities, of only which I'm going to focus on one, which is the corporate responsibility to respect human rights. Now, Ruggie's mandate was extended, and he elaborated on these principles in his initial report in order to produce what is now known as the UN Guiding Principles on Business and Human Rights. So specifically, he concluded that corporations should refrain from infringing on the human rights of others. They should address adverse human rights impacts with which they are involved. They should not cause or contribute to adverse human rights impacts through their own activities and address such impacts when they occur. As well, they should prevent or mitigate adverse human rights impacts that are directly linked to their operations. And today, the UNGPs represent the most current international standard for corporate responsibility for human rights. So now if we try to locate these initiatives on the continuum between soft and hard law, I think at first glance it's easy to say that these must all be soft law initiatives, in that they are all, of course, non-binding. But if we turn back to the criteria which are used to distinguish soft from hard law, so that was whether obligations are binding, the degree of precision that is associated with the obligations, and whether there's been a delegation of the interpretation to a third party, if we take a closer look, we can actually see that some of these initiatives actually bear some elements of hard law. So for example, if we look at the OECD guidelines, they contain a degree of precision in detailing the standards of conduct that corporations should bear, even though the guidelines themselves are not binding. Moreover, they delegate interpretation of the guidelines as well as to hold corporations accountable for failing to adhere to the guidelines to a reviewing body known as the national contact points, which are set up in individual countries. Thus, the guidelines actually lie closer to on the continuum to hard rather than soft law. Similarly, the ILO's Tripartite Declaration, again, another non-binding initiative, employs elements of hard law. So it too makes great effort in its precision in outlining the standards which are expected of corporations with regards to labor and employment issues. It also delegates interpretation of the declaration to officers of the Committee on Multinational Enterprises. However, the ILO declaration does not contain any type of monitoring mechanism or create a mechanism by which corporations can be held accountable. So in this case, it lies farther on the soft hard law element than, say, for example, the OECD guidelines, but they still remain far from just pure soft law. Conversely, if we look at the UN Global Compact, it occupies a position which is much closer to the end of pure soft law. The UN Global Compact contains only 10 vaguely worded principles, which are voluntary in nature, doesn't have any binding obligations, any degree of precision, or any type of oversight. So in short, if we look at where they might lie on the continuum, we can see that business and human rights initiatives can be spread across the soft to hard law continuum. Now, while none of these initiatives actually bear the status of hard law, some still reach well beyond the soft law threshold. However, we turn back to the UN guiding principles, which are the most current and one might argue the most influential BHR initiative in this area. We see that locating the UNGPs along the continuum proves a bit more difficult. In part, this is because John Ruggie deliberately grounded these principles in social rather than legal norms. So the corporate responsibility to respect human rights, which is found in the UNGPs, has specially been drafted not to be binding in nature, and therefore it cannot be hard law. So as a result, in locating the UNGPs upon the soft to hard law continuum, the starting point actually has to be at a position farther away from hard law in order to conform with the drafter's intent. Now, apart from the deliberate intent of its drafters, the UNGPs actually naturally position themselves away from hard law. This is because not only are they non-binding in nature, but their content is comparatively at a lower level of precision, and they do not delegate their interpretation to a third party. So this lack of systematic oversight and monitoring by an independent body, combined with a lack of binding and precise obligation, relegates the UNGPs much closer to the soft law end of the spectrum rather than to hard law. So as we can see, the business and human rights initiatives tend to oscillate between soft and hard law, with at least two of the more well-known initiatives occupying a position much closer to the soft law end. However, as the ILO Tripartite Declaration shows us, and the OECD guidelines demonstrate, these initiatives can gravitate closer to the hard law end of the spectrum, suggesting that if there is validity in hardening the business and human rights initiative, the possibility to do so exists. So this, of course, takes us to our next logical question, which is whether these initiatives should be hardened. Now, this is a difficult question to be asking in an era of increasing reliance on soft law as governance. Corporate governance in particular has been increasingly captured by the essence of soft law or voluntary standards. And this reliance seems to be driven by the idea that corporations are better placed than governments to determine how best to approach an issue in relation to their business. Now, soft law has also become a dominant fixture in the area of international financial regulation. In part, this is because soft law presents a superior solution to these types of areas where there is the need for flexibility because the objectives in this area continue to evolve. Nevertheless, reliance on soft law as a form of governance is plagued by two principal risks. The first is non-compliance altogether, and the second is that corporations may engage in symbolic compliance but fail to change their underlying approach to the issue at hand. So soft law as governance, therefore, must be strengthened. How do we do this? Well, we can take some lessons from international financial regulation. So one of the reasons that soft law has worked so well in that area is because of its precision. Parties make specific commitments to their behavior that they will and will not engage in, and these commitments are elaborated upon in memorandums of understanding and codes of conduct. Also, if you fail to adhere to these standards, you may face sanctions from bodies such as the IMF and the World Bank. And finally, you may be rewarded by the markets for your adherence to these types of regulations. So we can see that third-party oversight, precision, as well as market pressures may help soft law become hardened. So drawing from these lessons, can we also see what we could do to the BHR area? Now, to be sure, current BHR initiatives are actually well placed in the area of soft law governance, and this is because imposing regulatory controls on corporate activities impinges heavily on state sovereignty, as it impacts state relations with its citizens. More importantly, though, the business and human rights agenda is characterized by a lack of consensus or political will. Corporations do not agree on the responsibilities on this issue, and because of this, states similarly can't agree. Now, this lack of consensus is also complicated by the fact that corporations do not have a status under international law. So whereas international human rights law can place obligations on states for these issues, they cannot place similar obligations on corporations. Nevertheless, we can still see that business and human rights initiatives could still benefit from further hardening without actually becoming hard law. One approach to do so would be to introduce some form of monitoring. So an example of international financial regulation has shown independent monitoring can improve the effectiveness of soft law because it produces a form of oversight. We can also increase the hardness of soft law by ensuring compliance. Now, compliance could be assisted by clarifying the legal obligations that underlie business responsibilities for human rights. As these are unclear at the moment, it makes it considerably more difficult to convince a corporation of their responsibility in this area when the responsibilities appear only to be moral in nature. Now, compliance could also be fostered by better linking business respect for human rights to consumer interests and to other market pressures, in the hopes that markets will reward corporations that respect human rights. And finally, these initiatives can be further hardened by clarifying provisions within these initiatives. So for example, the Global Compact, which is currently worded only in broad and vague language, could benefit from a higher degree of precision, as well as the UNGPs can benefit from the same obligation. And that's because the UNGPs call on corporations to engage in what is known as human rights due diligence, yet they fail to explain what exactly this entails. And finally, if beyond hardening, the question arises, should BHR initiatives actually become hard law? Now, this is a very apt question to be asking at a time when countries are negotiating a binding instrument on business and human rights. And such an instrument could actually offer a lot of advantages, two of which would be to cover existing governance gaps, as well as increasing access to effective remedies for human rights victims. But the biggest problem in this area, and the biggest impediment to this treaty, is the fact that there is a lack of state support. So in fact, most of the world's largest states, which are the home to the world's largest multinational corporations, do not support such a treaty. So without support from these states, it is unlikely that the governance gaps that we hope to replace or to close with a binding instrument would not happen. We can also see whether we can learn some lessons from hard efforts at the domestic level. So let's look at France, for example. So in France, the legislature is currently debating a new law which will impose a duty of vigilance, the devoir de vigilance, on corporations. Now, under the proposed law, companies would be required to take reasonable care in identifying and preventing risk to human rights and fundamental freedoms, to severe physical or environmental damage, or to health risks resulting from the company's activities, the activities of those it controls, as well as its subcontractors or suppliers. Companies will be required to put into place vigilance plans, the plan de vigilance, that will identify these risks and determine reasonable measures for addressing these risks. And the law would apply to companies with more than 5,000 companies with a registered office in France, and companies will face civil penalties of up to 10 million euro for non-compliance. Now, in the UK, efforts to harden business and human rights law have also been undertaken, but they represent a much different approach. In fact, one would call a much weaker approach. So in 2015, the UK government introduced the Modern Slavery Act. So unlike the binding BHR instrument or the duty of vigilance in France, the Modern Slavery Act takes a much softer approach to utilizing hard law. It seeks to combat slavery and human trafficking by requiring corporations to prepare annual statements. And in these annual statements, a corporation must declare the steps it has taken to ensure that slavery and human trafficking is not taking place either in any of its supply chains or in any part of its own business. Now, while disclosure of non-financial information is a common soft law approach to corporate governance in many states, what makes the Modern Slavery Act different is that it requires the annual statements to be approved by the board of directors and signed by the directors. In addition, the statement must be posted on the corporation's website's homepage. As well, the Secretary of State has the authority to bring an injunction against the company in case of non-compliance. So if we compare that to the binding instrument on business and human rights and the French proposal on the duty of vigilance, the MSA is by far a weaker vehicle. But it brings together the essential aspects of effective soft law in a much more stringent manner. So the Act makes a very good effort at precision. It's binding and enforceable through the Secretary of State's ability to bring an injunction. Moreover, given that directors must sign this statement, the corporation can also be held accountable for its acts in the area via the director's duties. Most importantly, though, the Act enables a degree of monitoring or oversight. So as the statements must be provided to the government as well as to the public at large through the company's website, both the government and concerned citizens and NGOs can monitor the company's actions in this area. So the MSA acts as an interesting template for a hardened, but not a hard law, approach to the area of business and human rights. And this, I argue, could be instructive for the UNGPs. At the same time, it depends a softer approach to business and human rights issues rather than the binding instrument or the French law approach. So in conclusion, what we see is that the problem with the BHR initiatives are that they face a struggle between soft and hard law. On the one hand, it is an area with high opportunism costs and non-compliance, signaling the need for hard law. And on the other hand, it's an area plagued by high sovereignty costs and a lack of consensus, which signals the need for a soft law. Now, because of this struggle, the best way forward for business and human rights is to tread a path below hard law, but one that is still far from the end of pure soft law. Indeed, the way forward must be marked by significant hard law elements built into this otherwise soft law initiative. Thanks.
Thank you very much. I would like to open the floor for some questions.
Thank you for your presentation. I was impressed by this image showing the large distance between hard law and soft law. So the question raised from this is, depends on how precise, whether there is discretion, but what is needed for speaking about, or what degree is necessary for speaking about hard law? That is question number one. And question number two, let's say a state adopts the guidelines of the ILO to state law. Is this then hard law, or do we speak about soft law?
I think if a state adopts an international initiative into hard law, into their domestic law, that becomes hard law, as long as it's enforceable. That is, the state itself enforces it.
But the The discretionary elements are still in this regulation then?
The discretionary elements that you've adopted.
Yeah.
So that is, you have a choice as a state as to which, so if we look at, so for example, like an EU directive, if you have a decision as to which elements of the EU directive you want to put into your domestic law.
All the elements which are given to the company. These discretionary elements are not only for the state, but also for the company. You may tell this, or you may not tell this, and give information about that topic.
I mean, the idea is that if you have a degree of precision in the obligations, once you implement that into domestic law and it becomes enforceable by some sort of domestic authority, then we would consider that to be hard law. Obviously, that's the ideal situation. At least in the area of business and human rights, it's the reason that I don't even make that argument is that in most countries there's an unwillingness to take up international law. That's one of the reasons that they've been trying to fight for this business and human rights binding treaty at the international level for all those countries in the world that refuse to take on international law into their domestic law.
Thank you, that makes it clear.
Pardon, Lloyd, I generally agree with your arguments, but there are 3 generations of human rights: political rights, civil rights, the third generation, the economic, social, and cultural rights. But your presentation has not differentiated the different generations of human rights. Maybe some human rights, the right of life enjoyed by the employees or consumers should be protected by the hard law. But maybe some economic, social, cultural rights, like the right to be educated, or the right to breathe fresh air, maybe, or the right to work, depend on the soft law or depend on the voluntary social responsibility of the companies. So keeping the 3 generations of human rights in our mind, how would you recommend the national legislators or UN to propose different policies?
Well, so John Ruggie, when he dealt with this issue at the international level, talks about what is called a salient human rights. So those are all human rights in relation to corporations. So corporations obviously cannot, well, they could contribute to education, but they don't have sort of there's not a direct relationship between corporations and the right to education, for example. Whereas it may be more prudent for a corporation to become involved in something like helping to produce, although there's no human right, but on the environment. So what you look at is whether or not there is a relationship between the right in question and the corporate activity. So there are only human rights that corporations can actually, what they consider to be within their sphere of influence. Only those human rights are the kind of human rights that we ask corporations to respect.
Wonderful. I appreciate your idea of the precision. Maybe you could differentiate different types of human rights in your future publications.
Well,
I'm very looking forward to your wonderful books.
Okay.
Actually, the right to education enjoyed by employees in the business companies, and the right to education enjoyed by the kids, by the children in the rural areas, in the remote areas are quite different.
Right.
Okay. Anyway, I appreciate your vision. Thank you very much.
Sorry, can I just end? Yes, and then I think that's it now. Last question.
Thank you, Bernal. Very, very interesting and helpful talk. Here's the one I want to hear your thoughts on. If soft law, if one of the mechanisms for enforcement of soft law is market penalties for companies violating human rights, what evidence do you show do you have or that you've seen that occurs as opposed to the opposite occurring? So one would think that, and some investors would appreciate human rights violations, right? Because if it decreases the cost of goods sold, and when it was disclosed that Apple was producing its iPhones,
Foxconn, yeah,
right, its stock price didn't go down.
Mm-hmm.
Its consumers didn't opt out of the
Yeah.
iPhone and move to the Samsung. Anyway, so that's the question.
Yeah, I mean, market pressure is obviously not, there's no correlation necessarily that just because you've engaged in a corporate human right violation, that there will be an impact on the stock price. So, but I mean, your question was what evidence you had that there is. at least some sort of relationship. And the only evidence that I have is that there is a large market, the socially responsible investment market. So it's about, I think, 200 million, or probably more than that, where people invest in companies in which they believe that the companies are doing socially responsible issues. So of course there's some.
niche in the market compared to the market.
Of course, yeah. So there are specialty markets. So there are some people that are interested, but overall, are you penalized for committing a corporate human right violation? Not necessarily, but there is a growing interest. So what I'm saying, the argument that I was making is that we should encourage market pressures in this area, since there is this growing awareness. So when I first started teaching these kinds of issues about 5 years ago, there would be less students that would be interested in these kinds of topics. Now you can see that there are more and more people that are coming through that actually care about it, that want to make a conscious decision when they go out to purchase certain products as to whether they're buying from a socially responsible company. So this is something that's obviously going to happen gradually over time. Market pressures are not necessarily the answer, for I think, sort of the only answer. It's only one, but a number of different issues to look at.
Yeah, just a question. Thank you. That was a really interesting presentation, and raised a lot of different questions. I'm not sure that I can do justice to it, but I just want to focus on one part of it, which is this soft law to hard law continuum. My impression is that this use of soft law in human rights is a huge distraction, and it probably illustrates the problem with the very term soft law. I think it's a highly incoherent construct and completely a nonsensical idea in my view, because law by definition is something that is binding, and to use the prefix soft next to it doesn't make any sense, because it obfuscates law versus non-law for one thing, and claims legitimacy to things which are principles, standards, etc., with the use of the word law when they're nothing like law. And even internally it's inconsistent, because the things that you reference, financial standards, etc., they're not really soft law, and they're very different from soft law in the human rights or other contexts, which are proffered as examples, precisely because in the financial standard sense, they work without the binding element that law usually comes with, because there's a high degree of vertical integration in those domains, because there are very dominant intermediaries, whether it's the IMF or the World Bank or some other standard setting body, that can bring enforcement tools that are not necessary through the law, in the law sense, through sovereign bodies like states. So those examples of supposed soft law are quite different from human rights norms or standards, etc., because they don't have that kind of vertical integration in the human rights area. So if you moved away from the soft law concept, perhaps you can bring greater clarity to what you're talking about in human rights and corporations, which is rather to do with corporations as the subjects of international law, for example, right? I mean, which is not accepted, which is why we don't have any kind of binding law. So to use soft law, I think obfuscates rather than clarifies. And then if you move away from soft law into real law, you might have a richer explanation for why corporations are being subjected to human rights type expectations. And that might come in terms of legal type rules, like the California supply chain law, for example, or the Modern Slavery Act, or anti-bribery law, etc., where if you explain that in the same sense that you had human rights come into non-corporate law context, think about civil rights law and the civil rights movements, say in the US or any country before. So you had litigation from private parties, you had huge amounts of advocacy by interest groups, etc. That's how human rights became law in the domestic context in non-corporate law settings. Right? So that might help us understand, if you look at it like that, law versus non-law, rather than this soft law distraction. I mean, it's just a suggestion, and I'm not sure how you get there, but I think that might better explain what is going on than this soft law, because that's really nothing to do with what we're talking about.
Okay. Do I have time to answer that question? Okay, I'll give you a 10-second answer. So I don't know if I 100% agree with your premise there. So first of all, in international financial regulation, although we do have there are of course pressures from the IMF and World Bank, they're not an enforcement body. They're simply sanctions on certain states in this area. But actually, a lot of the soft law that that drives international financial regulations is cooperation and regulation between states. So if I put in an international financial regulation and you in Australia do not respect that, then I will not go to you the next time that I need you for something else. So the idea is that it works to this cooperative basis. So if we don't have that, then suddenly I turn to a different jurisdiction unless I need something specially from, I mean, maybe it doesn't work so well with Australia, but with a lesser country that wouldn't be so powerful, maybe I'll turn to you. So it's not necessarily just the IMF and World Bank are sitting there as sanction mechanisms. They are there to some use, but it's not the same kind of enforcement body, particularly since you could be talking about binding law. And the other thing is that you talked about the fact that there would be litigation that would be driving this forward, which of course would give us the very nice natural solution. The problem with international human rights issues is that most of these things take place in countries which don't have developed legal systems. So there's no ability for people to bring a lawsuit in Bolivia against an American multinational corporation. You're going to have to go to a different jurisdiction for that. So that's one of the reasons why law has not been as useful in this area that it would normally be, sort of like that we've seen in civil rights areas. Okay, I think my 10 seconds is up.
Thank you.
Okay.